Good afternoon, everyone, and this is Tripp VanderWal, a member of the Miller-Johnson Employee Benefits and Executive Practice Group. Welcome to our benefits lunch break on March 17, 2021. Happy St. Patrick's Day to everyone out there. I want to thank you for joining us as we take a deeper dive into kind of a health and welfare benefit update with some of the new guidance and added flexibility under the Consolidated Appropriations Act and other agency guidance that was issued after that. And then the American Rescue Plan Act, or ARPA, which was signed into law by President Biden last Thursday. Before we get started, let me just again remind you that we do host these employee benefit lunch break webinars on the third Wednesday of every month at noon Eastern Time. The next one is scheduled for April 21, so we hope you'll join us now. The plan is for some of my colleagues, Jeff Gray and Frank Barradin, to join me on April 21 to discuss some retirement plan topics. I say that's the plan because as most of you probably know, with everything that's kind of changing here still with legislation and agency guidance, related to benefit changes for COVID-19, we may end up having to sub that out if a more pressing issue comes out. But again, the plan is to have give you a break from having to listen to me walk through these webinars and have some guests on. So again, we hope you join us on Wednesday, April 21. Again, a reminder, there is a post-webinar series or survey, and we appreciate that if you would fill that out. That is very helpful for us in making this webinar as useful to you as it possibly can be, and in there throw in some topic ideas that you'd like to hear about it. Now, I will condition this on one thing, is we have gotten some topic ideas that are very, very narrow and may not have wide application. We probably can't spend a lot of time doing those very narrow topics. So, the more broad-based topic ideas you have, the more likely we are to incorporate it in a future webinar. Also, there is a Q&A feature which you can post question and answers in. I will try to kind of be monitoring that as I go about my webinar to respond to some questions. That is a little bit difficult when I'm doing it by myself. But I will try to spend a few minutes after the webinar answering any other Q&A questions or any questions that you may have. So very quickly, before we dive right in, today's topics are flexible spending account changes allowed by the Consolidated Appropriations Act, which was further clarified by IRS Notice 2021-15, and then another change we got under the American Rescue Plan Act. Some of you who attend our morning COVID webinar series may have attended last week, Monday. I did touch on these issues then, but I'm going to try to take a little bit deeper of a dive here for you guys that are probably a little bit more benefit focused than the general population that attends those webinars. We are also going to give an update on benefit plan deadline extensions under Ebsa Disaster Relief Notice 2021-01, which was issued in late February. And then we're going to have kind of a high-level overview on the Cobra premium subsidies under ARPA. Again, this was signed into law last week, Thursday, so we kind of have the skeleton or the bare bones approach how these subsidies are going to work, waiting on additional guidance both from the Department of Labor and IRS at this point. So I will imagine that this will be the topic of a more in-depth webinar in the future. And just so you are aware, we did issue a client alert, I believe, yesterday on this, so you can navigate that to our website, and hopefully that provides some additional insight that's helpful to you. All right, let's start with some of the changes that are allowable to flexible spending accounts. So under the Consolidated Appropriations Act, or the CAA, it really allowed added flexibility to flexible spending accounts. It added more flexibility. And most of the changes really were the intent to allow employers to provide additional opportunities to employees to avoid forfeitures under medical and dependent care FSAs under the what we call the use it or lose it rule. And the biggest two changes here is it allows unlimited carryovers for both medical and dependent care FSAs from 2020 to 2021 and from 2021 to 2022. It also allowed you to extend a grace period, which is typically 2.5 months, to a full 12 months after the end of the plan year, again, both for a medical FSA and a dependent care FSA, and again, for the plan years ending in 2020 and in 2021. What the IRS guidance clarified is that, I got some questions from clients that said, okay, Tripp, the CAA was signed on December 27th, 2020, very much at the end of the year. I was on vacation, it's in between Christmas and New Year's. We haven't historically allowed a carryover or a grace period under one or both of the FSAs, but we're kind of interested in adding this added flexibility. Are we, what can we do? And at that point I said, well, clearly you can add it for 2021, but the question is can you do it for 2020 now that your 2020 plan year is done? And under the normal rules, the answer to that question was no. The addition of a carryover or grace period for a particular plan year would have to be added by a formal amendment before the end of the plan year, and of course communicated to participants. IRS Notice 2021-15 clarified that said, hey, no, under this added flexibility by the CAA, you can add a carryover or grace period for the 2020 plan year, even though it's already done. Again, as long as you or your third-party administrator can administer the carryover or grace period. So again, for those of you that potentially were interested in adding one of these features to your FSAs in 2021, but we're holding off because you didn't think you could do in 2020, we arguably can do it. The key is we should talk to our third-party administrators, make sure they can administer it yet for 2020. For example, they haven't kind of irrevocably forfeited the amounts for 2020 already. Finally, the IRS guidance said that you can still only offer a carryover or a grace period under a specific FSA. You could have a carryover under the health FSA and a grace period under the dependent care FSA, but one FSA can't offer both. But the IRS guidance did basically say, but we realize, that maybe you want to do one or the other. So if you currently are offering a grace period and want to do a carryover, unlimited carryover, you can essentially suspend one in order to offer the other. Now, before you race to start thinking whether you should do that, the IRS really did say the unlimited grace period and the unlimited carryover and the extended grace period really do offer the same relief. Typically an unlimited carryover offers, an amount to carry a limited amount, which is now $550, but potentially, into the next plan year or plan years after that, where the extended grace period allows you to carry over an unlimited amount, but only for a limited period of time into the next plan year, which was 2.5 months. Now these rules have really kind of mashed together and offer the same benefits in the fact that you can basically use all of your unused account balance for the entire next plan year. In fact, even a grace period that would end, for example, on, for the 2020 plan year would end on 12/31/2021. You can actually pick the amounts up in that grace period and offer it in another grace period that would end 12/31/2022. So you can actually bridge these grace periods together. The one difference that you may consider offering the grace period instead of the carryover is if you're going to allow this new spend down feature of medical FSAs, and I'll touch on that here in just a second. But let's walk through first what the spend down of medical FSAs is, and it really says, hey, for an individual that terminates participation during in a medical FSA during a plan year in 2020 or 2021, you as the employer can allow them still to submit expenses incurred after the termination and be reimbursed, but only to the extent of their their account balance as of the date of termination. They're not going to contribute anymore. So if they're sitting, they terminate participation, for example, they terminate employment, or for any other reason, you can say, hey, for the remainder of the plan year, you can still incur expenses and submit reimbursement, but only up to whatever, maybe it was when they terminated, they had $300 left in their account, only up to that $300. For those of you that have dependent care FSAs, a spend down feature has always been allowed for a dependent care FSA, so it's going to operate, much like those. So for some of you, you may be familiar with that. But the IRS guy gave us some important clarification. So if you decide to, and again, all of these added flexibility under the CAA are optional to employers. I should have specified that. But if you decide to offer the spend down of the medical FSA feature, that's not going to absolve you from your obligation to offer Cobra to participants who are eligible for Cobra. So if a participant terminates their participation in a medical FSA due to a Cobra qualifying event with a positive medical account balance, you still have to offer them Cobra. The one difference in how Cobra and the spend down features are going to work is if you elect Cobra, of course, a participant is going to have access to their full medical FSA contribution for the plan year, but they're going to have to pay Cobra premiums. Now, if you elect the participant elects the spend down feature, that's going to be any termination of participation. It's not going to be limited to just those Cobra qualifying events, and they're not going to have to pay Cobra premiums, but they're only going to have access to their account balance as of the date of termination. And again, kind of circling back here to why maybe you would want to offer an extended grace period versus an unlimited carryover is if you offer this spend down of a medical FSA. If I terminate, for example, my medical FSA in the middle of 2021, and my plan offers an extended grace period, I can continue to spend down not only through the remainder of the plan year, but into that grace period. So it's going to last potentially longer than the plan year. Now, if I terminate mid-2021 and my plan offers the spend down of the medical FSA, but instead offers the carryover, my amounts at the end of the plan year under the medical FSA, whether I've used them or not, essentially terminate and are not going to be eligible to carry over. So again, I think that's probably maybe the one nuance between offering an extended grace period, a 12-month extended grace period, versus an unlimited carryover. For those of you who have kids that are were near the age of 13, kind of when the COVID pandemic hit and threw some money into a dependent care FSA, thinking you were going to have dependent care expenses, only to find that your dependent care facility shut down due to COVID, and you're thinking, my goodness, all that money's gone. The CAA offered some relief to you. So typically a dependent care FSA can only be used to pay for dependent care expenses for children before the child's 13th birthday. The CAA allowed additional flexibility and said for a dependent care FSA can reimburse expenses incurred on behalf of a child who turned 13 during the plan year in which the annual open enrollment period ended on or before January 31, 2020. So it gives you, for kids that obtain 13, it gives you one more year to use that dependent care FSA as long as they turn 13 in the plan year for which the annual open enrollment period ended on or before January 31, 2020. Another way to think of that is that's probably the first plan year that begins on or after February 1, 2020. CAA goes a little bit farther and says for the plan year after that, you can also use a dependent care FSA to pay for expenses for kids who turn 13 in that previous year or will turn 13 in the next year, but only for amounts that you carried over from the plan year for which the annual open enrollment period ended on or before January 31, 2020. So this is kind of a mouthful, so let me maybe give you an example using a calendar year plan. So for the 2020 calendar year, if I had a kid that turned 13 during 2020, I can use my dependent care FSA to pay for that kid's dependent care expenses even after they turn 13. If my dependent care FSA allows for a grace period or a carryover unused amounts from 2020 into 2021, I can also use my dependent care FSA to pay for that 13-year-old in 2021, but only amounts available from 2020 under the grace period or carryover. And let's say I had another kid that in 2021 turned 13, I could still use those 2020 amounts to pay for that kid's dependent care expenses in 2021. Again, if I drop in new money in 2021 into my dependent care FSA, that is still going to be limited to kids that are both younger than age 13, so 12 or under. Shifting gears a little bit, we got a slight change under the American Rescue Plan Act of 2021, or ARPA, and that basically had a provision that said a participant in the 2021 tax year is eligible to receive $10,500 of dependent care assistance, and that is an increase from the typical limit of $5,000. For those employees that are married filing separately, that is still going to be half the amount, but now that is increased from the current $2,500 to $5,250. This presumably allows an employer to allow increased contributions, either employer or employee, to a dependent care FSA in 2021. I think we are going to want to see additional guidance from the IRS on how this is all going to work. Specifically, if you have a non-calendar year dependent care FSA, this only applies in the 2021 tax year, and if tax year is defined based on the employee, that's most likely going to be the calendar year. So how are these limits going to work? If you have, for example, a dependent care FSA that runs September 1 through August 31, that's a great question. I don't really know that. I think the other thing that you're going to want to consider is the IRS going to give us some relief from the non-discrimination rules that apply to dependent care FSAs? Let's be honest. So let's focus on one, the 55% average benefits test, which basically says that for non-highly compensated employees, which are generally employees making less than $130,000 in a year, their average benefit under a dependent care FSA has to be at least 55% of the average benefit of highly compensated employees. If you uncap this and allow employees to drop in $10,500 into their dependent care FSA in 2021, it's more likely that the highly compensated employees are going to put more money in that. That could make your plan run afoul of the 55% average benefits test, which generally requires the employer to kind of reclassify reimbursements under the dependent care FSA for highly compensated employees as taxable reimbursements, and they keep doing that until they get down to where the 55% average benefits test is satisfied. So again, I think, before you grab onto this with two hands, you may want to wait to see what the IRS says about the non-discrimination test. And I realize that puts you kind of between a rock and a hard place, because if you do want to allow this, you probably want to give employees, make this change as soon as possible to give employees as much time in 2021 to make the increased contributions, because the later you put it in, the bigger salary reduction that's going to come out of an employee's pay. I think the other thing to consider is if you have already thought or implemented extended carryover or a grace period on the dependent care FSA side from 2021 to 2022, how do those two things work together? We've offered for example, again, let's use the carryover. We've offered an unlimited carryover under the dependent care FSA from 2021 into 2022 to avoid forfeitures. And now we're going to come in here and make this change where we allow you to just dump more money into the dependent care FSA in 2021. To me, that seems a little counterintuitive. Now, it's not necessarily impermissible, but you may want to think about that. Now, if you do go ahead and add this increased contribution to your dependent care FSA for 2021, you do have to have a formal amendment to your FSA, which is likely going to be in your Section 135 plan. And a retroactive amendment is permissible if it's adopted by the last day of the 2021 plan year. So again, you have some time to make a retroactive amendment, but not as much time as you'll see that you have to make some of the other changes that are permitted under the Consolidated Appropriations Act. Finally, the Consolidated Appropriations Act and Notice 2021 offered additional flexibility for participants to make mid-year pre-tax election changes under their Section 125 plan. For those of you that are familiar with the 125 plan rules, is generally you have to, during the open enrollment period, you set your elections and you pay for your elected benefits on a pre-tax basis, and you can't change those pre-tax elections unless you incur certain events. Well, because kind of things are so hard to plan for with COVID going on, the Consolidated Appropriations Act says, well, with respect to medical or dependent care FSAs, if you, the employer, want, you could allow your employees to make mid-year election changes on a prospective basis under a medical or dependent care FSA for any reason. And I think you need to be careful with how you do this, because again, there's some nuanced rules that come through in Notice 2020-15. We did do a client alert on that, and you may want to review that. It's on the firm's COVID webpage. You could, for example, allow a participant to stop their contribution. Now, if you allow them to stop, I think you need to make a decision. Does that say, okay, your participation's done and you can only be reimbursed from expenses that incurred before your termination ended, to the extent you have account balance, or you just stopped your contributions and you can still be reimbursed after your termination to the extent you have an account balance? I think you've got to make that distinction. Of course, if you're going to let someone reduce the amount they're contributing, you can't allow them to reduce less than the amount that they've already contributed. So they can't use this change to get a refund. What's in the dependent care FSAs, or at least being accounted for already, can't be refunded. And under the medical FSA, which of course is subject to the uniform coverage rule, you don't want to allow a participant to reduce an election below the amount of what they've already been reimbursed for the year, because then you're assuming an experience loss. So you're going to want to set those guardrails, and the IRS guidance has said you can set guardrails on what mid-year election changes are going to be made, when they're going to be made. So you could say, hey, we're going to say in April, you get, for the month of April, you can make these mid-year election changes. Here's what's available. Well, come April 30, you're done. And now after April 30, you're only going to make a mid-year election change if you otherwise incurred an event under Section 125 that permits a mid-year election change. The CAA only permitted mid-year changes without a reason under medical and dependent care FSAs, but IRS Notice 2021-15 extended that to group health plan coverage, which includes medical, prescription drug, dental, and vision. Again, so participants can make mid-year pre-tax election changes with respect to these benefits for any reason, should you, the employer, want. Now, again, just because you say, hey, you employee, you can enroll mid-year without any reason, that's not a HIPAA special enrollment event. So if you're fully insured or you're self-funded with a stop-loss carrier, you may want to talk to your carriers and say, hey, if I let mid-year enrollments for folks that didn't have a HIPAA special enrollment event, are you going to cover them? And because if they're not, you're not going to want to allow mid-year enrollments. Now, of course, that's not a concern if you're going to allow mid-year disenrollments under your plan. One thing to note, that if for employees, this doesn't appear to apply to spouses or dependent children, if they request to drop medical or RX coverage, they need to provide you, the employer, with a written attestation that the employee has or will immediately enroll in other comprehensive health coverage. So whether through another employer plan, for the example of spouses, Medicare, Medicaid, TRICARE, which is military insurance, CHAMPVA, coverage on the exchange, they just need to either have or attest that they will immediately enroll in other comprehensive care. One other thing I want to point out is the mid-year changes under the medical FSA also appear to include conversions either from a general purpose to a limited purpose medical FSA or from a limited purpose to a general purpose FSA. And that may be helpful for an employee, for example, that changes from a high deductible health plan to a non-high deductible health plan mid-year, or vice versa, because of course if you participate in a general purpose medical FSA, you're not eligible for an HSA. So if, for example, I've been enrolled in a traditional PPO plan, my employer opens up the opportunity to change and I change to a high deductible health plan, maybe, and I was participating in general purpose, maybe I also want to allow an election to convert that general purpose to a limited purpose on a prospective basis so that I can start making or receiving HSA contributions. All right, so if you are an employer that's going to decide to allow any of these changes or all of these changes, you do need to formally amend your FSAs, which again are likely part of your Section 125 plan. The CAA and the IRS guidance give you some time to basically make formal amendments, which are signed amendments. And the rule is that the amendment must sign or be formally adopted by the last day of the calendar year that begins after the plan year for which the amendment is effective. So here we have an example, again, of a calendar year plan year, I think, because those are the easiest. So we have a change that's going to be effective during the 2020 plan year. You must have your formal amendment in place and signed by December 31, 2021. That's, of course, because 2021 is the calendar year that begins after the 2020 plan year, and December 31 is the last day of that calendar year. Now, keep in mind that, as I pointed out earlier, if you decide to increase the dependent care FSA limit, which is allowable under Arpa, your amendment has to be done by the end of the 2021 plan year. So that may speed up your traditional when you otherwise think you have an amendment. And now, shifting gears just slightly, for those of you, which is probably anybody that has a medical FSA or HRA, you're aware that under the CARES Act, which was passed last March, I think, basically said FSAs, HRAs, HSAs could start reimbursing over-the-counter drugs and medicines without a prescription and menstrual care products beginning January 1, 2021. Now, with respect to medical FSAs and HRAs, there's IRS rules that basically says before they can do those reimbursements, you have to have an amendment in place. What we found is that third-party administrators of these FSAs and HRAs were kind of automatically allowing reimbursements without even permission from their clients as a matter of uniform administration, which basically, since the client hadn't even okayed this, they certainly hadn't put an amendment in place, so kind of brought their medical FSA and HRA out of compliance with IRS rules. Well, in Notice 2021-15, the IRS said, you can retroactively amend these arrangements to cover OTC drugs without a prescription and menstrual care products as of January 1, 2021. And it really didn't give you any time that you had to adopt that retroactive amendment. Now, keep in mind, if your arrangement was audited and didn't have that amendment, that may be problematic. So I don't see any reason that we would wait too long to get those amendments in place now that we know that our plan is going to allow those expenses. All right, benefit plan deadline extensions. Going back, so I think it was May of 2020, we got Ebsa Disaster Relief Notice 2020-01, under which the Department of Labor and the IRS had certain election periods or certain deadlines under employee benefit plans, specifically Cobra election deadlines, premium payment deadlines, and the requirement for both qualified beneficiaries or the employer to provide the election notice, mid-year enrollment requests due to HIPAA special enrollment events, and then claim and appeal submissions are going to be extended or tolled during the outbreak period. And the outbreak period began March 1, 2020, and ends 60 days after the presidentially declared national emergency declaration for COVID-19 expires, which that hasn't happened yet. We don't know when it's going to happen, so the outbreak period goes on. Well, I think when the agencies issued Disaster Relief Notice 2020-01, they were naive, like I was, maybe like many of us were, that this was going to go on for as long as it has. So the problem is that the IRS and DOL only have the statutory authority to extend these deadlines for a period of 1 year. So the big question was, on February 28, 2021, which was 1 year from the beginning of the outbreak period, what happens? And there was different ways that different employee benefit practitioners interpreted this. On one side, you could interpret it on February 28, all the deadlines, deadline extensions expire, and on March 1, basically everything is going to be due. Whether if you had backed up Cobra premium payment deadlines, they're all going to be due on March 1. The other side of the spectrum on this was to say, no, all the deadlines are going to lift kind of on either 1 year statutory limitation on deadline extension is going to apply on a individual by individual basis. So if I elected Cobra, I've got a Cobra premium payment, April 1, 2020, April 2, 2020, or I'm sorry, May 1, 2020, June 1, 2020. Those are going to start slowly coming to, the deadline extensions are going to expire March 1, 2021, April 1, 2021, June 1, 2021 on an individual by individual basis. Kind of in the middle of the interpretation that was mine, and as you'll see, incorrect, was we're just going to unhit the pause button on March 1, and all these deadlines are going to start ticking and rolling again as of March 1, 2021. On February 27, a Saturday no less, the agencies released Disaster Relief Notice 2021-01. And under their interpretation, they went the way that basically said, hey, it's going to be most beneficial for participants because the 1 year statutory limitation is going to apply on a deadline by an individual by individual basis, but of course is going to be harder for employers and their third-party administrators to administer. So for example, if I had a Cobra election deadline on April 1, 2020, that is going to be extended through to April 1, 2021, which is 1 year later. This notice also said that employers should act reasonably and in the interest of employees and families who rely on benefit plans for their economic well-being. So if you miss a deadline, maybe you're a little bit flexible. Now, if you're doing that specifically with respect to fully insured or comprehensive health plans, you're going to want to make sure that your carriers, your stop-loss carriers, are on board with your flexibility. It also recommended sending notices to affected participants about the end of the extension. It didn't require it, and so whether you send it or not is kind of up to you, but I think if you sent notices that were previously incorrect, that are now incorrect based on Disaster Relief Notice 2021-01, you may want to send additional notices to clarify those errors. One thing to think of that I've seen circulate a few times, which kind of loops our first two subject areas together, is I have employers, again, that have said, okay, I can offer an unlimited carryover under my medical FSA. I'm going to do that. And I'm going to say, so, from 2020 to 2021, my medical FSA, you have to have all your claims from 2020 submitted for reimbursement by 90 days after the end of the year, or March 31, 2021. And as of March 31, 2021, we're going to close out the 2020 plan year, but all of your money is going to roll over and be eligible, available to reimburse 2021 expenses. Well, I see how that's maybe necessary as a matter of administration, but it does fly in the face of this disaster relief notice. Because technically, under Ebsa Disaster Relief Notices 2020-01 and 2021-01, that March 31, 2021 deadline for 2020 claims is a claim submission deadline that needs to be extended at least to the end of the outbreak period or 1 year. So right now we're looking at March 31, 2022, unless the outbreak period ends earlier than that. So again, I think the problem is how do we process the rollover while keeping the 2020 claim submission deadline open for an extended period of time? Not sure. I unfortunately don't have a great answer on that. I think you could probably process the rollover as of March 31, 2021. But the extent a participant shows up with a 2020 claim, says, hey, I didn't get this in time, but this is an eligible expense, you got to process that, and it's going to have to come out of their account. And arguably, it will have to come out of their account from the 2020 plan year, but maybe that may be irrelevant, now that I think about it. All right, finally, I think our last topic for today was Cobra premium subsidies under Arpa. I did get one question. It says, did the Arpa have any impact on emergency paid sick leave? I don't know the answer to that. I believe that it extended voluntary or paid sick leave, which was first passed under the FFCRA. That's more an issue that some of my employment law partners are handling. So if, feel free to shoot me an email if you want me to chase this down for you. I unfortunately do not have the answer to that question. All right. So for those of you that have been doing this benefits game for several years, you remember after the Great Recession, back in 2009, the government passed the American Recovery and Reinvestment Act of 2009, and that contained Cobra premium assistance subsidies, but they were only 65% of the applicable Cobra premium. The good news is the law in Arpa uses a lot of the same provisions from the 2009 law. So we think that will operate somewhat similar back to that 2009 law. And the reason that that's helpful is until we get guidance from the Department of Labor and IRS on how these Cobra premium assistance subsidies are going to work, we can look to some of that previous guidance, and I think we can kind of gain some, understanding or get an idea of how the agencies are thinking they're going to administer this. But there are some important nuances. Of course, the biggest one is that under ARPA, which was just passed and signed by President Biden, the Cobra premium subsidies are 100%, not 65%. So who is eligible for these Cobra premium subsidies? And the law uses the term assistance eligible individuals, and these are basically any individuals who became eligible for Cobra due to an individual's involuntary termination of employment or a reduction in hours. And before, let me point out one thing. I've got a lot of questions about what happens if someone is terminated for performance issues. Is that an involuntary termination? Or what if they no call, no show, and they're terminated? Is that involuntary? And I would say, yes, that is probably still an involuntary termination. Now, the only exception to that is whether you got to the point and you think that employee's termination was due to their own gross misconduct. Because if it's subject to, if their termination is subject to their gross misconduct, not only are they not going to be eligible for a Cobra premium subsidy, they're not going to be eligible for Cobra, period. The problem, of course, is that different courts in different jurisdictions have interpreted what gross misconduct means differently. But I'm going to be honest with you, it seems to be a pretty high threshold. So, for example, someone that is terminated due to performance issues or lack of performance, or someone that is terminated due to no call, no show, I think it's a stretch to say that they were terminated due to their gross misconduct. So they are probably going to be eligible for the Cobra premium subsidy. So again, only folks that become eligible for Cobra due to their involuntary termination of employment or reduction in hours, even if the involuntary only applies to the termination of employment. It doesn't apply to reduction in hours. So if the reduction in hours is voluntary, I got to take some time off because my kids can't go to school, they're also potentially going to be eligible. Now, oddly, if someone says, I actually got to quit to take care of my kids because I can't go to school, that's a voluntary termination. But again, and the involuntary termination or reduction doesn't need to happen during the period in which Cobra subsidies are available. It could have happened before April 1. We'll talk about that period in a second. And as long as they are eligible for Cobra, their Cobra eligibility period overlaps with the subsidy period, they will be eligible for the Cobra subsidy. Individuals who became eligible for Cobra for other reasons, so for example, divorce, legal separation, dependents who basically turn 26 or age out, they are not eligible for Cobra premium subsidies. The Cobra premium subsidies are available beginning April 1, 2021, so starting next month, through September 30, 2021, unless they're terminated earlier. So how can you be terminated earlier? The law says eligibility for another group health plan. And for this purpose, a group health plan does not include accepted benefits, dental or vision only benefits, medical FSAs, or qualified small employer HRAs. But it could include eligibility under a new employer's plan or, for example, a spouse's group employer plan. Now, keep in mind, this is eligibility for, not necessarily enrollment. Using the IRS's guidance from the 2009 law, it doesn't appear to apply during waiting period, though. So let's say I am involuntarily terminated from my employment. I am eligible for this Cobra premium subsidies, but effective May 1, I am rehired by a new job, and I'm eligible for their group health plan, but I have a 30-day waiting period. So I'm essentially going to be eligible on June 1 of 2021. My subsidy is going to end on June 1, 2021, whether I enroll in coverage or not. And there is a requirement, I'm sorry, I'll address that in a minute. Also, it can end for eligibility, not necessarily entitlement to, but eligibility for Medicare, and then the exhaustion of your normal Cobra period. Now, for folks who become eligible for another group health plan or become eligible for Medicare, they have an obligation to notify the group health plan providing Cobra coverage of that eligibility. If they fail to do that, they could be subject to a $250 penalty unless the failure was due to a reasonable cause. If they intentionally fail to notify the group health plan providing Cobra, their penalty could actually be up to 110% of the Cobra premium subsidy they received if it was greater than if that amount is greater than $250. So how much is the Cobra subsidy? Again, it's 100% of the applicable Cobra premium. And the entity advances, the entity that advances the Cobra premium, which we'll talk about here in a minute, is going to be eligible for a refundable tax credit against the entity's Medicare tax. So again, either the employer, insurer, or in certain situations, a multi-employer plan is going to have to advance or fund these premium tax credits, but it's ultimately going to be paid for by the federal government through these tax credits against an entity's Medicare tax. Based on the IRS's previous guidance under Arpa of 2009, it appears to include the 2% administrative fee. What I think is unclear is what if someone was terminated from employment, let's say back in, reach way back there and say August of 2019, involuntary terminated back in August of 2019, their 18-month Cobra window expires before April 1, 2021, but they were determined to be disabled by the Social Security Administration and are eligible for a 29-month Cobra premium period. And so that's going to bring them into the subsidy period. But now you're charging them 150% of the applicable premium. Does the subsidy include this 50% premium? I have no idea. I think this is another area that the IRS is going to have to weigh in on and hopefully give us guidance. On one hand, I could see how, if you treat it the same as a 2% administrative fee, then maybe it is covered. On the other hand, I think, maybe now you say, hey, this extended period of coverage is no longer due to the individual's involuntary termination of employment. It's due to their disability, so maybe they're not eligible for a subsidy at all. I don't know the answer to that. Keep in mind that the subsidy does not, the credit does not include employer subsidies towards Cobra. So if you had someone that was involuntarily terminated from employment, maybe you have a severance agreement that said, I'm going to pay 50% of your Cobra premium. Well, it's really not going to, the subsidy is going to offset what the Cobra qualified beneficiary is going to pay. It's going to drop it to zero. But you as the employers are only going to be eligible to claim for the credit the amount of the subsidy, which does not include the amount that you were contributing under a severance agreement. So again, employer says, I'm going to under a severance agreement, I'm going to pay 50% of your Cobra premium. You qualified beneficiary pay the other 50%. Well, the subsidy is going to offset the 50%. Qualified beneficiary is not going to pay anything, but you as the employer are only going to claim the credit for the 50% that is not considered to be paid under the severance agreement. Some other changes that are allowed is if you want, as an employer, people that are eligible for the credit may be allowed to switch to a lower cost Cobra coverage option within 90 days of receiving the revised Cobra notice, as long as that other coverage option does not include accepted benefits, medical FSAs, or QSARAs. Again, this is only allowed if you, the employer or plan sponsor, permit it. Individuals are also going to get another opportunity to elect Cobra after April 1. So first, again, individuals who are eligible for the subsidy who have not elected Cobra as of April 1, 2021, will get, from 60 days from the date that they get the revised notice, will be eligible to elect Cobra, but that Cobra election will only give them retroactive coverage back to 2021. Further, it looks like any qualified beneficiary, not just the folks that are eligible for the premium, who previously elected Cobra but discontinued it before April 1, 2021, will get an opportunity to elect it again. Now, arguably, they're not going to get the subsidy, they just get an election. I think a big question is how this is going to work with our extended deadline period under Ebsa disaster relief notices 2020-01 and 2021-01, which we talked about earlier. And let me give you an example. So let's say, I have an individual that was involuntarily terminated from employment July 1, 2020 of last year, and I haven't elected Cobra yet. Now, under Ebsa disaster relief notice 2020-01, I have until July 1 of 2021 to elect Cobra. And if I did that, my Cobra election would be retroactively all the way back to July 1, 2020, but I would owe those Cobra premiums. Well, under this new ARA exception, it looks like I would have the ability to elect Cobra as of April 1, 2021, but it would be for free. But I'd have a gap in coverage. Now, it's going to be interesting. The IRS and Department of Labor are going to issue model election forms to see, is it going to give people that opportunity to elect coverage as of just April 1, or do they have to go all the way back? A little bit unclear. The way I interpret it is they're basically going to have to give it a choice because nothing about Arpa changed or even mentioned the relief under these disaster relief notices. So under the disaster relief notices, you still kind of have this opportunity to elect Cobra back to July 1, 2020, and under Arpa, you have this kind of separate election to elect coverage back to April 1, 2021. So that's going to be a difficult thing to administer, I think. Of course, with all these changes, we're going to have temporary revised Cobra election notices. So all Cobra election notices, regardless if it goes to someone who's eligible for the subsidy or not, between April 1 in 2021 and September 30, 2021, are going to have some additional information. It's going to have to talk about the availability of the Cobra premium subsidy, and if permitted by the employer, the opportunity to switch coverage options. Now, again, if you're not going to permit that, it arguably does not have to include that information. This election notice must be basically redistributed to participants who already got an election notice by May 31, 2021 to those individuals who have kind of the second bite at the apple to elect Cobra. So again, those are premium assistance eligible individuals who became entitled to Cobra before April 1, 2021, even though they've already been provided a Cobra election notice. They have to get this again by May 31, 2021, and once they get it, we'll have 60 days to re-elect Cobra if they want. Again, and then all other individuals who had the opportunity to elect Cobra effective April 1, 2021 under Arpa who have the second opportunity. So again, I think additional guidance on how some of all this is going to work is really going to be helpful, and hopefully the DOL is working expeditiously on creating that and getting it out to us. The Cobra election notices are going to have additional content. You can see here it's forms necessary for establishing eligibility for the subsidy, contact information for someone that can ask questions about the Cobra subsidy, a description of the additional opportunity to elect Cobra, that second bite of the apple rule, a description of the qualified beneficiary's obligation to notify the group health plan of eligibility under a group health plan or Medicare, and presumably the penalty if they fail to, a prominent description of the qualified beneficiary's right to premium assistance, including any conditions on that assistance, and then again, if the employer allows, a description of their ability to switch coverage options. There's also going to be another notice that's required in certain circumstances, and that's basically to notify people, hey, you're getting to the period where your premium assistance is going to end. So that has to be set at least 45 days and no less than 15 days from the date that the premium assistance will end. It has to tell them, first of all, the date that it's going to end. Second, that they may be eligible for Cobra without a subsidy or without premium assistance through Cobra or another group health plan. Now, there's an exception. This notice is not going to be required if the Cobra subsidy is terminated due to eligibility for another group health plan or for Medicare. And I think presumably that's because how am I as a plan sponsor of a group health plan going to know at least 45 days in advance, or at least 15 days in advance, that you're going to be eligible for another group health plan or for Medicare. So if that's the reason if the Cobra premium subsidy ends, you are not required to send this notice. Again, for the Cobra subsidies that are paid for or advanced by certain entities, they will be eligible for a tax credit against the entities, against their Medicare tax, for coverage provided under a multi-employer Taft-Hartley union plan. It is the actual multi-employer plan that's eligible for the tax credit to the extent they pay Medicare tax. That'll be an interesting thing because I can't imagine multi-employer plans have too many employees, but I could be wrong. The plan sponsor, if the plan sponsor is self-funded or it's fully insured and the plan is fully insured plan is subject to Cobra, it's the plan sponsor or the employer providing the plan that's eligible for the tax credit. And then for all other fully insured plans, so for example, fully insured plans sponsored by an employer with less than 20 employees, that may be subject to state continuation coverage requirements, it will be the insurer that's eligible for the premium tax, or I'm sorry, for the tax credit equal to the amount of the Cobra premium subsidies provided. With that, it looks like we have a couple questions. Let me go through those. Does Arpa require subsidies for accepted benefits? The answer to that, it depends on what you mean by accepted benefits. Does it apply to a medical FSA? The answer to that is no. Dental and vision only plans are also considered to be accepted benefits. But again, those appear to be covered under the subsidy rules. So if I elect coverage under dental only or vision plan, that appears to be eligible for the subsidy. That is based on the law's definition of group health plan, and that's also how the law worked back in 2009, is that subsidy was available for dental only and vision only coverage. Okay, someone who's on FMLA has run out and now subject to Cobra. Are they eligible for the subsidy? So I think the answer is potentially. If the reason, if they did not, they didn't come back after FMLA, so now we've treated them as a termination. Now, remember, it's got to be an involuntary termination or a reduction in hours. So I think you have to go back to how their coverage ended after FMLA expired. If ultimately the cause was they didn't come back, if we treat that as a voluntary termination, then they're not eligible for the subsidy. But if it was an involuntary off, or they just came back on a limited basis and it was reduction in hours and now they're not eligible for coverage, then they're potentially eligible for the subsidy period to the extent that their Cobra period overlaps, with the April 1 to September 30 window. Okay, let's see. Can you give an example? What about someone terminated 3/15/2020? Can they elect 4/1/2020? If so, when does their Cobra end if they were involuntarily terminated? So here I think, remember, if you are involuntarily terminated, so on March 15, 2020, so last year, your Cobra window is actually, your Cobra period is going to run into the subsidy period. So if they can elect, if they didn't previously elect, and that coverage will be effective 4/1/2020. Now, under disaster relief notice, their opportunity to elect a year late has already expired, so they won't have the opportunity to elect back to March 15, 2020, but they potentially can elect back to 4/1/2020. And their Cobra will expire when it would have otherwise expired had they elected back, so it measured 18 months from 3/15/2020. Okay, so next question. Wouldn't it be more beneficial for employees who elected coverage under the exchange, since the premium is being waived for the rest of 2021 for those who qualify for unemployment? Will there be an updated model notice for the ACA subsidies? This is a great point, not one that I touched on in this webinar, but I did in my webinar last week Thursday, and that is if you are eligible for or received unemployment in 2021 for at least a week, and you buy coverage through the exchange, your premium tax credit that you get will completely wipe out your obligation to pay the premium. So if you were involuntarily terminated from employment, you're absolutely right. It may be better for you to have coverage through the exchange, since you're essentially be getting free coverage outside of your participant cost sharing, like deductible, copayment, and coinsurance requirements, you'll get premium-free coverage for 2021. Now, that's not going to apply if I'm involuntarily terminated from employment and I may not be eligible for unemployment for some reason. Or, for example, I had a reduction in hours and that was the reason that I lost coverage, but again, I wouldn't be eligible for unemployment. So again, if you're eligible for unemployment, it may be smarter to go with the free coverage through the exchange than the 6-month Cobra premium-free subsidy. Okay, a few more here. So Cobra qualified beneficiary had Cobra, but it ended for whatever reason, only to have option to elect Cobra as a 4-1. They do not qualify for the subsidies. So again, these are non-subsidy individuals. So I became eligible for Cobra because I was divorced, and I said, hey, I don't want coverage before April 1, 2021. I'm going to terminate my Cobra coverage. If my Cobra coverage period would still extend longer, I terminated earlier, yes, I'm arguably going to have the opportunity to re-elect Cobra as a 4-1, but of course I'm going to have to pay for that. Is this medical Cobra or dental only vision? Again, I think I answered this a little bit earlier. So I think we have to wait for IRS guidance, but based on the previous law from 2009, it appears that it will apply to medical, dental, and vision. I do not believe it will apply to EAPs, but I could be wrong. Again, based in 2009, it did apply to medical coverage, dental only benefits, and vision only plans. Okay, do we need to send an updated Cobra notice to someone who voluntarily retired on March 30, 2020? Again, if you want to look back at the IRS's previous guidance, I think it was IRS Notice 2009-27. You can find it by Google. It has a whole series of questions about when a termination is voluntary or involuntary. If this was truly voluntary, then no, I don't think a Cobra, someone who truly voluntarily retired on 3/30 would arguably not be, not necessarily be subject to, you would not be required to send them another Cobra election notice. But the question is whether their retirement was voluntary. I think the IRS guidance goes into saying, hey, if I retired knowing that if I basically didn't retire, that my employer is going to let me go, then maybe it could be classified as an involuntary employment, and then they are a premium assistance eligible individual, and then the notice requirement is going to apply. So again, hopefully the IRS will issue additional guidance, but you can try, I think, I wouldn't take it to the bank, but I think you can review IRS Notice 2009-27 to look at some of the areas where it gave some additional guidance on whether or not a termination was truly voluntary or not. Is the Cobra eligibility period affected by this? Does the original qualifying period get adjusted if someone did not elect initially? Enrolls April 1 with the second bite of apple. Does this mean the 18 months starts April 1? Nope. As the way it appears, or the way the law is written, that if I elect under the second bite of the apple and my coverage is effective April 1, it's still going to terminate based on my original 18-month period, which is measured back from my original qualifying event date. All right, what about someone who's been on Cobra since March 2020? Do they stop owing premiums as of 4/1/2021? And the answer is yes, as long as that person's Cobra eligibility was based on an involuntary termination of employment or a reduction in hours. And so you're going to have to work with your Cobra vendors to stop collecting premiums, because if you collect a premium, that premium has to be refunded to that individual within 60 days. And I think this brings up one other issue, that I'll discuss before we sign off here, is what about those pesky 2% administrative fees that are charged by the TPAs? Typically those are charged to the qualified beneficiaries, and before the TPA remits the premium to the insurance company or the employer, they withhold that 2%. Well, now they're not going to have those premiums coming in from qualified beneficiaries. So they may be sending, those TPAs may be sending you, the employer, a charge for that 2% administrative fee to the extent that they don't waive it. Now, maybe they'd be willing to waive it because if I'm not collecting premiums, am I truly administering anything? It's a good question, probably a good question for your Cobra TPA. But if they're going to charge that, they're probably going to be expecting you, the employer, to pay it. But of course, you can include that in your tax, your your tax credit against your Medicare tax. So ultimately, it should be refunded. Okay. One last question. I think that will be it for the day. Would an employee on an extended workers' comp leave be eligible for the Cobra subsidy? The health insurance was recently terminated due to exceeding FMLA eligibility. Would this could be considered an involuntary reduction in hours? Remember, involuntary only applies to termination of employment. It does not, the limitation of involuntary does not apply to reduction in hours. So I could go into my employer and say, my kids are still doing remote schooling and I just have to be home with them. I need to cut my hours back to 15 per week. And my employer says, okay, but your health insurance is going to cover to end to that. I become eligible for Cobra. I am eligible for the subsidy because it was my Cobra I became eligible coverage due to a reduction in hours, even though it was my voluntary asking to reduce my hours. So again, I think, we keep trying to throw some, different elements to these questions, but ultimately, if the reason that individual became eligible for coverage was the involuntary termination or reduction in hours for any reason, and their Cobra period overlaps with the subsidy period of April 1, 2021 through September 30, 2021, then they are potentially going to be eligible for the Cobra subsidy. With that, I think we'll call it a day. Again, I want to thank everybody for joining me today and remind you, please join us back April 21, and I think we're going to hit on some retirement topics that period. So thanks again, and everybody have a wonderful St. Patrick's Day.